All right. Hey, Chalk and Gavel listeners, believe it or not, for the first time, Chris and I are actually recording an episode in the same room. We're here in Orlando at the Education Law Association's annual conference in front of a live studio audience. Thank you. Yes, make yourselves known so that our audience believes us. There you go. All right. We usually have to edit a lot of mistakes, so this could be very interesting or disastrous, but this is going to be fun. We're going to have a good
blast.
It's going to be a good time. Hopefully the audio won't be too questionable, so we're in a room that I would say didn't really have podcasting in mind when it was designed.
When you called it a studio, that was very generous.
Did I say studio?
You did.
Okay, I'll have to edit that. So the acoustics are a little rough, and it's Florida, so there's an industrial air conditioner providing a little bit of ambiance, but it is what it is. So before we get started, let's do a few of our little reminders and promo items. Chris, you started off.
Yeah, so please help us by taking a moment to rate and review Chalk and Gavel on your favorite podcast platform. We'd love it if you'd go to chalkandgavel.com. We've got a feedback form up there. We're always looking for ways to improve the show and give people the education law content that they want. We also have on our website a link to our teaching guide. So if you need an education law resource for your classes or your trainings, or if you just want to share an episode with a friend and want to find an episode by topic, please check out our teaching guide. You can find that at chalkandgavel.com.
Yeah, and we would also be very grateful if you would consider supporting us on our Patreon site. Just $2 a month will help us keep this little show going and help us pay for all this equipment that's sitting in front of me here. And we might even be able to do some bigger and better things. So go to patreon.com/chalkandgavel, and that would be awesome.
Absolutely. And lastly, we are here at the Education Law Association Conference. We'd love to once again tell you how amazing this organization is. Obviously, I don't have to tell you all in the audience, the physical audience, not the audio audience. If you're interested in education law, this is absolutely the best place to be. It's where Jamie and I found our people. So please consider going to educationlaw.org and becoming a member. And if you can join us for the 2025 conference, we will be in Kansas City. But I think that's it. So on to the show. What First Amendment rights to free speech do students have in the elementary school classroom? How can schools teach the essential values of kindness, tolerance, and respect for others? Is recess really all that important for first graders?
I have a second grader, and I can tell you right now, I would feel very sorry for his teacher if he didn't have recess. So, yeah, I think it's pretty important.
Our 4-year-old is very much the same way. He needs to have a lot of time to jump off stuff.
Exactly. Today, we're going to talk about a recent case involving a first grade student who, after a lesson about Martin Luther King Jr., gave a Black Lives Matter drawing to her friend and was disciplined by the school for doing so, after her friend's mother complained to the school. The court had some really interesting things to say about the free speech rights of some of our youngest students. So let's not waste any time and dig into it. This is the pretty wild case of BB versus Capistrano.
Oh, yeah! So the kids are alright. So the kids are alright. So the kids are alright.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. So the kids are alright. So the kids are alright.
All right, Chris, you got a bell ringer for us today?
I do. So this is an update to a case that we've been following pretty closely. So there's a new development in Parents Defending Education versus Olentangy Local School Districts. This is a case about a group of students and parents who are suing the school to prevent the school from punishing students for intentionally misgendering their classmates.
We covered this case.
We covered this. This is one of the first cases we ever covered.
Like, what was it, episode 3, 4?
Episode 4.
Yeah.
So we covered this back when it was at the district court level, and the district court found for the school, dismissed the case. But there's a new twist because the plaintiffs asked the Sixth Circuit to hear the case en banc, meaning that they requested that all of the active judges in the circuit hear the case after the Sixth Circuit panel affirmed the lower court decision in favor of the school. And so the Sixth Circuit granted that request. So the entire Sixth Circuit will now hear the case. So it is still going and still moving up the chain. So an en banc review is basically the last possible step before it gets to the Supreme Court, if it ever gets to the Supreme Court.
Right. Yeah. And when we talked about this case back in episode 4, so this is Parents Defending Education versus Olentangy. And while Chris said that this particular case was talking about how the school's policy was about intentionally misgendering a kid, we also talked in that episode about kind of a companion case that was happening at the same time, which was Parents Defending Education versus Linmar, which kind of went the other way because the policy, which we kind of talked about how it was a similar policy in spirit, it was worded very, very differently,
It was worded very broadly because the policy in Linmar just said that they had to respect their transgender classmates, whereas this policy said, essentially, we view intentionally misgendering students as a form of bullying and harassment.
Right, whereas the other policy was looking at it more like compelled speech kind of.
Yeah.
I mean, they called it unconstitutionally vague language, right?
Yes, exactly. And the compelled speech is actually an argument here in this case, basically saying that they're being compelled to express a viewpoint that they might not agree with.
So now they're going to get an en banc hearing.
An en banc hearing before the Sixth Circuit, which...
Tell us about those judges, Chris.
Yeah, so this is, I think, going to be... They might come out a different way than the lower courts because...
Why do you say that?
There are 16 active judges on the Sixth Circuit, 9 of whom were appointed by Republican presidents, 7 by Democratic appointees, including 6 who were appointed by President Trump in his first term. So far, every judge who has sided with the school's position has been a Democratic appointee. So if you're merely counting votes, things might not be looking as good for the school, but this case raises such an interesting tension between school authority and First Amendment free speech, and that's something that we've seen some conservative justices really kind of struggle with. So like Justice Alito is a great example, right?
Yeah.
Where he is a very strong advocate for free speech, but he's also highly deferential to school authority in specific situations. So like it's going to be one of those situations where
he's going to be very confused. Yeah.
I don't know if I would say that. We're probably going to be very confused reading the opinion. So this case, and the other big conflict here is just between the First Amendment and anti-discrimination laws and like the protection of diverse individuals. So like it's going to be an interesting case to watch just because of how complex these issues are.
Yeah, absolutely. Well, we will follow along with developments in that case, and we will keep you all posted. We really say that every single time. And you know what? I think we've done a pretty good job.
Yeah, because we covered it in episode 4. And then we did, when the Sixth Circuit decided it, it was also a bell ringer. So we are following through.
Yes, there you go. We're true to our word. All right.
This time.
You want to get into this for now. You want to get into today's case?
Let's do it. I've got my soapbox ready.
Okay. So this is also a speech case, and it's a case about schools winning student speech cases, like the Olentangy one, or at least up until now. So our case today, BB versus Capistrano, takes place at an elementary school in the Capistrano Unified School District, which is in Orange County, California. So unfortunately, the facts in this case, this is a recent case, 2024 ruling. The facts are a little sparse. Not a lot of news reports out there. There's some stuff that was written by some advocacy groups, but most of that stuff just kind of follows very closely with the court records.
Yeah.
So there's a lot of reading between the lines in this case. But here is what we know. So we've got a first grade student, like all of the minors or most of the minors in the cases that we cover. We don't know the name, we just know the initials. It's BB. So BB was in first grade. We think this was probably because this case involves something about Black Lives Matter, and because of the timing of the court case and what we know, we're thinking that the events took place around 2020-ish, around the Black Lives Matter sort of when that movement was kicking off. And but we don't know for sure. So when BB was in first grade, her class learned about Martin Luther King Jr., and as a part of that lesson, the teacher mentioned something about Black Lives Matter, which makes perfect sense if you're trying to connect history to present times.
Yeah, I
right?
love that.
Yeah, and we don't know exactly what she said about Black Lives Matter. We don't really know much of anything.
Yeah,
we don't know if it was a passing phrase, or if it was a passing comment. We don't know if she really kind of dug into it or how much. We just know that it was mentioned, okay? So sometime after the lesson, BB made a drawing of her and her 3 classmates. Remember, BB is in first grade. And I've got a second grader. I know what those drawings look like, right? So she made a drawing of her and 3 of her classmates, all with varying skin tones. And above the drawings, BB wrote the phrase, Black Lives Matter, in big black letters. Now, she only put 1 T in matter because she's in first grade.
She's in first grade.
So we're not going to count that against her. So it actually did say Black Lives Matter, which we're here at Disney. Yeah, it's appropriate because we're here at Disney, and that reminded me of Tow Mater from the movie Cars, because I've seen that 14 times.
Because you have a second grader. So this is all sounding good so far, right? Like
I think so, but guess what? We're talking about it here on the show, so something happened.
Yes.
So here's what happened. Underneath Black Lives Matter, BB wrote any life in smaller purple letters, okay? BB then gave the drawing to a classmate who took it home. The classmate, according to the court report, was her friend. That's all it said. Gave it to her friend. All that we know about her friend, whose initials are MC, is that she is a student of color. The court document does not include any more information than that. Now, when MC's mom saw the drawing, she was not happy, okay? And she emailed the school and said that she would not, quote, tolerate any more messages given to MC at school because of her skin color, unquote, and that she, quote, trusted the school would address the issue, unquote.
Right. Yeah. And so this is one of those situations you mentioned, kind of reading between the lines. Like, it sounds like the relationship between MC's family and the school is a little rocky right now. And like, we don't have any context for other things going on, but like MC's mom seems to be experiencing this drawing amongst a larger kind of body of incidents.
Which may or may not involve the school. We have no idea. Like, we don't know what is prompting the concern.
She says any more messages given to her daughter at school because of her skin color. So,
right,
like,
but
there's a pattern.
I mean, I guess it's possible that she could say this, that she's kind of saying, this is the first incident, I don't want any more. Like, you could interpret it like that, possibly. So, but again, this is case in point that there are very limited facts here, and we're doing a lot of trying to read between the lines.
Right, but because she, sends that email that is, it's assertive, right? It is saying like, look, here's how I want to handle this. It's not collaborative. It's not like that. So like, to me, that reads as if like, this isn't the first thing that this family has had to deal with.
Yes. And that's a little foreshadowing, folks. We're going to talk about being collaborative a little bit more on this episode.
Something we mention a lot, actually.
I think so. Okay. So after receiving that email from MC's mom, the school principal approached BB at recess to discuss the drawing. He told her that the drawing was, quote, inappropriate, unquote, and, quote, racist, unquote. Though there is conflicting testimony in there about whether or not he did say racist. He also apparently told her that she was not allowed to draw anymore and asked her to apologize to MC, which BB did twice.
Twice. Hey.
So she was forced to apologize, not allowed to draw.
That one's weird.
And that is real. Like when I read that,
Yeah.
I was like, what?
I wonder if that's BB's recollection of the events, because we don't know how that conversation went, right?
No.
Whether it was a, hey, BB, can you tell me about the drawing you gave to your friend, right? That's a very different conversation than saying that was bad, that was inappropriate, please never draw again.
Yeah. But wait, Chris, there's more. So when BB came in from recess that day, little did she know that was going to be her last recess, because two of her teachers pulled her aside and that she said that she was not allowed to play at recess for the next 2 weeks. Why?
Wow.
Why do you say?
Yeah.
We don't know, and apparently neither did BB.
Oh, because they never explained
No.
the connection. And it doesn't sound like the principal and the teachers talked about it either, whether they coordinated their punishment, which, I'm sitting here thinking double jeopardy, right? You can't punish them twice, but, it's a school, so.
Yeah, it's 4 times here. Apologize, no recess,
Right.
stop drawing.
Yeah.
So she was never really told why she was not allowed to play at recess. So what happens next? Absolutely nothing for a year.
So we're done with the episode?
You should all be so lucky. So nothing happens for a year. And after about a year, after the drawing incident, BB's mother, whose name is Chelsea, and another parent were discussing an unrelated concern about the school. And that other parent told BB's mom about the drawing incident.
Oh, and this is the first time.
This is the first time BB's mom is hearing about the drawing incident.
Wow. But wait, how did the other mom hear about it?
Oh, I don't know, but a very different way than,
Yeah, not the way, if I'm a school leader, that I want my parents learning about incidents involving their kids.
Yeah, exactly.
Yeah.
Exactly. So that parent told BB's mom about the drawing incident, and needless to say, BB's mom, not too happy.
Not too happy.
No. So she filed a complaint with the school, and even after appealing, it was completely unsuccessful.
Okay. So filed a complaint with the school, went up the ladder, didn't get what she wanted.
No. So basically...
Yeah. So the thing that kind of catches me here is, we've got these two parents talking about an unrelated thing about the school, and it comes up. So, that other parent had to hear about this somehow. So, it feels like there's something here about the school and its relationships with its families, at least with these families, right?
The information pipeline at this school seems a little, little strange.
Yeah.
Yeah. So after she got nowhere with the school, what happened?
Well, as always happens if we're talking about it, she filed a lawsuit.
Hey.
So BB and her mother filed a lawsuit against the school, the principal, the teachers. They brought suit in the United States District Court for the Central District of California, because these are federal constitutional claims, alleging that the school violated BB's First Amendment right to free speech when it punished her for her drawing. The complaint also included some California state law claims based on some other conduct, because this was kind of a pattern. This seems like one of those situations where the parent was kind of pushed to the last straw. That's not that saying at all, but that's all right.
Okay.
Pushed to her limit. There it is. So after some motion practice and some discovery, the school defendants moved for summary judgment. So they were arguing that there were no issues of material fact, and even when viewing the facts in the light most favorable to BB, they were entitled to judgment as a matter of law. So that's where we're at for this decision. And so the court has to grapple with BB's First Amendment claim. So BB's position is that the principal and teachers by forcing her to apologize, by asking her to stop drawing, by having her miss recess. All of that violated her right to free speech.
Okay.
And immediately I can tell I'm not going to agree with everything in this opinion, because the first sentence after the court describes BB's position, the court writes, quote, "However, this schoolyard dispute, like most, is not of constitutional proportions."
Oh, boy.
Yeah. So I got a couple issues with this sentence. The first is that proportions implies like degrees, right? So like that means that there's some free speech issues that aren't of like constitutional concern, and that's different from like being a constitutional violation, right? So like
Right.
that, like if it implicates free speech, I would say it's of constitutional proportions.
Yeah.
Right. The other thing is like that schoolyard dispute language.
Yeah.
It feels
that's really.
right. It's like really pejorative,
Yeah.
right? Like,
Yeah.
oh, this is so insignificant.
Yeah.
Because I don't think it is for a lot of reasons, which I think is
It's like, why are we even talking about this?
exactly
Yeah.
right.
Yeah.
And I'll tell you why. Because the court got it wrong. But I'm getting ahead of myself. So anyway, we've talked about the constitutional framework for addressing student speech a few times. But as is usual with these cases, the court starts with Tinker's pronouncement that students, quote, "do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gates." Love it. I like
Yeah.
it so far.
Yeah,
We're off
yeah.
to a good start. But the court doesn't stop there. The opinion goes on to say that, quote, "because educators best understand the special characteristics that transform students' rights in schools, courts give educators substantial deference as to what speech is appropriate." And now I'm going to lodge my first disagreement, because that sounds like the court's job.
Yeah. And the court has made it their job on so many occasions.
Right, yeah.
Right?
Yeah, what is appropriate in school from a constitutional perspective
Yeah,
is the court's
is the court's
responsibility.
job.
Yeah, but that deference to school authority is going to be a theme throughout
Right.
this opinion. And that's actually something that has come up, a tension that has really come up in these student speech cases, is that tension between how much do we defer to school authority versus how much do we protect students' rights. And so like that's
Right.
a perennial
But
issue.
Right. And the courts are there to help us wrestle with that.
Exactly. And
But they're kind of just saying, nah,
they're abdicating their responsibility,
Right.
right? Or maybe they are. I don't know. Let's keep going.
let's see what happens.
So both the school and the family agree that the drawing is what is called pure speech. So it falls under the Tinkered standard. This isn't one of those exceptions for lewd and indecent speech or speech that could reasonably, in quotes, be inferred to promote illegal drug use. Like this is pure speech. So we're under Tinker, and Tinker says that student speech can only be punished if it causes or is reasonably anticipated to cause a material and substantial disruption, or if it interferes with the rights of others. And most of the Tinker case law is about the material and substantial disruption prong.
Right.
What's really interesting about this case, one of the things that's really interesting about this case, is that it deals with that second prong.
Right. Well, because the first one really doesn't
Oh,
apply here.
there's no
nothing-
incident of a disruption, unless you count the principal having to answer an email.
Oh, yeah. We don't do that often as principals.
Yeah, no.
Not
Empty
part of the
inboxes,
job
right?
description.
So because that second prong hasn't been litigated that much, the court has to kind of, look through the case law, and it distills 3 broad principles to kind of help us address when school violates that second prong of Tinker, the interference with the rights of others. So first, the court says that where speech is directed at, quote, particularly vulnerable students based on, quote, core identifying characteristics, such as race, sex, religion, or sexual orientation, educators have greater leeway to regulate it.
Okay.
Yeah, that makes sense, right? Like, we want to make sure that schools are a safe and inclusive space where everyone feels welcome and invited, and that speech, speech like that can be incredibly harmful. It doesn't have much benefit, right? So if we're thinking about like the value of the speech, it's very low.
Yeah.
So,
I get that.
yeah, I am on board.
Okay.
But
There's always a but.
there's always, yeah.
Okay.
There's always something else. So the second thing that the court says is that, and this is where we're going to start disagreeing with the court. Well, maybe I am. Quote, the mere fact that speech touches upon a politically controversial topic is not sufficient to bring it under the First Amendment's protective umbrella.
Wait.
Yeah, so the court is basically saying, like, just because it's political doesn't mean it's automatically protected. And, like, that by itself is not controversial.
No.
Right? But it does seem to imply that, like, this political speech is not as protected as it ought to be, right? Because, like, this pure speech, this political speech is kind of, like, at the apex of protected speech. And so to say, like, just because it's political doesn't necessarily mean it's protected seems to kind of undermine the importance of that kind of speech.
So is it basically saying to administrators, like, if go crazy, if something makes somebody uncomfortable, go crazy, do whatever you want?
Well, a little bit, actually, now that I kind of think about it. But it goes on to say, the court goes on to say that school administrators must have a justification above, quote, the mere desire to avoid the discomfort and unpleasantness that always accompanies an unpopular viewpoint. So that's straight from the Tinker case.
Okay, good.
So there is this kind of recognition that, like, just because it's political doesn't mean it's protected. We've got to make sure that people, we protect vulnerable people and that we avoid kind of this bullying, harassing language, this dehumanizing language. And we can't censor speech just because it's unpleasant or it might lead to discomfort. So, like, there's already a lot of, this is already complicated, right?
Yeah.
But
it's going to get more complicated?
It gets more complicated because this is a first grader. Because the last thing the court says is that the third principle the courts address when thinking about this sort of stuff is that age is an important factor when deciding whether speech is protected under Tinker.
Under Tinker.
Under Tinker.
So, like, we've talked about age when it comes to cases like Bethel, right, which is the lewd and vulgar, and and what a high school student might understand, about particular speech is different than what an elementary. I get that, but they're talking about under Tinker here.
Under Tinker, yeah.
So now they're basically saying schools can suppress speech if it causes a disruption, if it violates the rights of others, or if you're 6.
Exactly. Yeah.
Okay.
That's kind of the court's perspective here. And, I think age does matter, right? Like,
yes.
It absolutely does matter. I think it matters differently than what the court says here. So let's dig into kind of what the court's reasoning is for how age matters.
Okay.
Because the first thing the court does is it quotes Tinker, which actually is quoting West Virginia versus Barnett, and it says that we protect students' rights in schools to avoid, quote, strangling the free mind at its source. So I love this idea because, like, it shows that students in schools are learning their constitutional rights. They're learning the value of those rights. They're learning how to express that and how to form their own opinion and all of that stuff. Absolutely love that. But the court goes on to say, quote, an elementary school, by contrast to Tinker's high school, is not a marketplace of ideas.
What?
Yeah. So 2 timeouts on that one, right? First, one of Tinker's plaintiffs, Mary Beth Tinker, was a middle schooler. So that part is just wrong.
Yeah, I think she was junior high because I don't think they had middle school back then, but not many. But she wasn't in high school.
Jamie, I don't know. I wasn't there.
He's implying that I was. I was not. She was in eighth grade.
Yeah. So, and the second kind of the bigger concern that I have with that idea that elementary schools aren't the marketplace of ideas is that if we embrace this marketplace of ideas concept for the First Amendment, I think it actually gives us really good reasons to protect elementary students' speech.
Yeah.
So they might not be engaging in kind of the robust public discourse. They can't vote, right? But, like, neither can most students. But students do have unique perspectives and experiences that no one else has. No one else can tell us what it's like to experience school as a first grader. We've all been in first grade, but, like, if we were to try to describe it now, we're describing it with another 30 years worth of, whatever Before
experience,
social media, like, that's just a perfect example. And we saw this during the student protests following the Parkland shootings. Students were telling us how they experienced the threat of gun violence in schools and how schools had been responding to that and how that had affected them so incredibly. So things like code red drills and all of the anxiety that students were feeling about the threat and responses to gun violence in schools, like that was a huge theme of those protests. And if those students weren't telling us that, we would never have learned that perspective because we don't know what it's like to experience school from their perspective. So like this marketplace of ideas matters.
Yeah, and on top of that, I would say that like it doesn't exist in a vacuum. The elementary school doesn't exist in a vacuum, and they're dealing with things and they're supposed to be learning about these things. And, you know, I've said it 3 times on this show, I've got a kid around that age. I can tell you right now that he is more than capable of having discussions about the things that he is experiencing, right? Yeah. And not only is he capable of it, but he wants it. He's curious. They're very curious at this age, right?
Oh, they're sponges, right?
Yeah, like, which goes back to the point that we were talking about before on the chalk side of this about like, you know, when everybody gasped when we said it was a year before the mom found out that this had happened. Like I, as a former principal, I talk about a missed opportunity to, you know, to talk to a child, to get a parent involved, to get all the parents involved. Like,
well, if you like that, the next thing the court says is that it discusses the difference about what students are learning in elementary school versus high school. And it says, quote, elementary schools are more about learning to sit still and be polite rather than robust debate. So, Jamie, that connects perfectly.
I can't believe they put this stuff in writing.
I want to know when the last time this judge was in first grade, or in a first grade classroom for that matter.
I'm not going to say what I'm thinking right now.
Right. So the court concludes that kind of by saying that to fulfill the mission, elementary schools require significant latitude to discipline student speech. And they say, indeed, much, perhaps most, of the speech that is protected in high schools may be regulated in elementary schools. So, Jamie, to your point earlier, that perhaps most speech can be regulated in elementary schools, like, I think that way overcorrects, right? Like, that seems, you know, I know you made a joke about, you know, and if you're 6 is now another carve out to tinker, right?
Right.
And that seems to be kind of what the court is saying here, though. You know, they don't explicitly say that. They kind of put it in this larger analysis. And I find that quote obviously really problematic, right? Because allowing students to engage in protected speech doesn't necessarily mean like we have to hand control of the school over to students.
Right.
And there need to be guardrails, right? Like, and that makes sense that younger students will need stronger guardrails, but it doesn't mean that the values of free speech like disappear with young students.
Right. And it also doesn't mean that they're not capable of understanding where those guardrails are.
Exactly.
Right?
Yeah. And if we want them to like grow into these active, engaged citizens, we should probably give them a chance to practice, right? Like I like to think of these as training wheel rights, right? Like these are the rights that we put on their bicycles or before like, and my 4-year-old just got his big boy bike for his birthday.
Oh,
so
that's fun.
Training wheels are front of mind.
Nice.
But yeah, so like it's really problematic when this court is saying like we need
I can see that conversation now. Like, son, I've bought you some training wheels for your bike, but let's talk about training wheels. I've got a few other things to say about them.
These are allow you to develop in a safe and productive way so that you can emerge into your full capacity. Yeah, no, that's what it is, right? That's exactly how that conversation went, too.
Mom, Dad won't let me ride my bike.
So the court's saying, like, you know, we want students to sit there and be silent and learn how to sit passively. Like, oh, that seems really problematic.
Yeah, that works with my kid.
I'm sure, right? Yeah. Especially if we want these kids to grow into active, engaged citizens.
Yeah.
Maybe we should give them the chance to practice and not just teach them silence and passive deference, right?
Right.
And that all connects kind of to the last argument that the court makes, because the court recognizes that it's not just the speaker's age that matters, but also the age of the audience, right? Because this was first graders speaking to other first graders.
Okay.
And so the court explains that first graders are impressionable. If other students join in on the insults, the disruption could metastasize, affecting the entire learning environment of even more students. So there's a concern
So
here.
they're taking this little schoolyard dispute
To use the court's language.
Right, to use the court's language, something that is just like, it's a thing. And they're making it sound actually pretty big.
Right, it could become bigger,
It could
right?
become huge.
But that cuts both ways, because right, if we're learning about if we're worried about the impressionability of young students,
Yep.
yes, we want to make sure that captive audiences and young, impressionable students who have to go to school, we want to make sure they're protected from harmful speech that could affect their well-being and their development.
Right.
But we also need to consider the development of other values in educational lessons, right? So
Yeah.
one of the primary justifications for protecting free speech, besides the marketplace of ideas, is that it's necessary to protect autonomy and our ability to kind of develop our ability to be the authors of our own lives.
Yeah.
And so if we value that, then we want to help students, young children, develop into autonomous adults. So silencing their speech when they're really, really impressionable sends a really strong message that your speech doesn't matter. And that really curtails the development of their future autonomy and really undermines those other educational goals.
Yeah. Sounds like you might have written a book about this.
I don't know.
If not, you should. You should.
So that's what the court says. And ultimately, Jamie and I were not asked to judge this case.
They never ask us.
They never ask us our opinion.
You know.
So let's see how all of this played out for B, though I think at this point we can probably guess how this all came down. So the court gave significant weight to the fact that this all happened in first grade and unsurprisingly concluded that the speech was not protected. So the court started with the message itself. The court compared that phrase, any life, that BB added to the drawing to the controversial phrase, all lives matter, right? Which, the court describes that as kind of being widely perceived as racially insensitive and belittling when directed at people of color, right? Because that was kind of a rejoinder to Black Lives Matter. And absolutely, right? Like, we have testimony from MC's mom that those kind of messages are harmful. Absolutely, right?
But yes. But that we also just have testimony from MC's mom. We also have
BB's perspective.
We also have BB's perspective and what was reflected in the court record about how she gave a drawing to her friend.
Right.
And we can't discount the fact as well that she's in first grade
and doesn't know the full meaning or context for what she's writing, right?
Possibly.
Potentially, yeah.
Yeah,
and the court recognizes that BB's intentions, and the court even says BB's intentions were almost certainly innocent and were coming from a place of empathy and care, right? So the court actually acknowledges that.
So they say it.
Yeah.
All right. Great.
But for the court, according to the court, Tinker doesn't ask about the speaker's intention. It only looks at the impact, which actually puts Tinker at odds with a lot of First Amendment doctrine, because most First Amendment doctrine looks at the speaker and the speaker's intent. And the Supreme Court recently, in recent years, has been really kind of honing in on
the Brandy Levy course
of intent.
Court case. And
exactly.
Yeah, totally.
So, because we're looking at impact here, the court says that the school principal reasonably viewed all of this as impacting or potentially impacting the right of MC to be, quote, let alone and not be subject to speech that kind of denigrates a core identifying characteristic. And the court gave incredible deference to the school authority because it's an elementary school. And that was enough to allow the school to punish BB for her speech.
But again, I'm going to say this again. The mom was not involved at all. The school never reached out to the parent.
To BB's parent?
To BB's parent.
Yeah. Yeah, and there's so many things here, right?
And it doesn't look like there is any follow-up either with MC's parent or, there's nothing in there that talks about any sort of dialogue between the school and the family.
Right. And that's one of the huge things here is just the importance of these relationships. Right. And there's so many opportunities, I think, in this case to develop those relationships.
To have it not have become a case?
Well, I think that's the punchline of most of our cases.
Right.
But yeah, that importance of open communication, of dialogue, because it seems like there's a vacuum here.
Yeah.
Or at the very least, there doesn't seem to be some level of mutual trust that we would hope that those kind of open communications would really develop, right?
Yeah. I mean, we talk about it on this show all the time about the the importance of relationships. We talk about it in our classes that we teach, about how, in so many of these cases, one thing that seems to be implied is a lack of a healthy relationship between the school and different parties. And I don't know, the lack of those healthy relationships just always feels like a recipe for disaster.
Right. Yeah, because imagine how this case would go, potentially, if they approached it from a more restorative perspective, right? So, if we had a conversation with the school leaders, BB, MC, and both their parents immediately after the school administrator got that email, right?
If my kid did this, and the school didn't reach out to me, I would be furious, because this is an opportunity here, right?
Yeah.
I would be furious.
Yeah, absolutely. And, thinking about kind of that relationship and taking a more restorative frame, I think that another key takeaway from this case is, if all you've got is a hammer, then everything's going to look like a nail, right? So if you're approaching all of this from a punitive perspective, then
everything is punishable.
Everything is
and so worthy of punishment.
Exactly. And I think that's really problematic because of there's so many competing interests here, right? We talked about so many competing interests, and reasonable people are going to disagree about how to balance all of those interests. And so because of all of these different interests, because there's educational concerns on both sides, I think we need to address student speech in ways that value both sides of that. And so just coming in with that blunt instrument of punishment, doesn't seem to do that. So if you can address student speech in educational ways that emphasizes both kind of your educational concerns and those concerns that we, legitimate concerns, right, that we've talked about, about empathy and respect for others, along with kind of the value and importance of the speech itself, then, we can do all of this, affirm the value of those things, affirm the value of free speech, and we can do all that in ways that maybe don't punish students for what they say. And, maybe we can have our cake and eat it too, right?
And I don't know. I think that 6 and 7-year-olds are capable of engaging to some degree in those
And the worst thing is the knee-jerk reaction that just says, these students should be seen and not heard, right? But unfortunately, actually, no, not unfortunately, because here's what's happening now. So the court granted the school's motions for summary judgment, so declined to hear the state claims. So that ended the parents' complaint, except they then appealed that to the Ninth Circuit. So this was the trial court's decision was from February of 2024.
Okay.
It is currently on appeal at the Ninth Circuit Court of Appeals. So we will see what the appellate court does with all of this.
All right.
Maybe, what we should do? We should submit this episode as an amicus brief.
As it? Oh, okay. That's being at this conference, I've heard a number of people call it an amicus brief.
I've heard it both ways.
Have you? Mater, mater.
Exactly.
All right. Well, it's a very interesting case. A lot of very interesting potential implications here, I think. We will follow this. We will report back once we hear something about the next steps here. But until then, Chris, like we do every episode, give us our homework.
Your homework is to wait with bated breath for us to provide an update on this case, because we do follow up. We proved that with Olentangy.
That's right.
But you can go to chalkandgavel.com. You can find our teaching guide there, as well as a feedback survey. We'd love to hear your thoughts. You can find us on social media at Chalk and Gavel. We'd love to continue the conversation. Like, rate, review us. And thank you so much for our live
audience.
Studio audience.
Thank you. All right.
This has been an absolute
this
blast.
was fun. This was a lot of fun.
Yeah.
We'll have to do this again in 2 weeks at UCEA in LA.
I look forward to it.
All right. We'll see you in 2 weeks on the next episode of Chalk and Gavel.